Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content that we're going to start today to really get into our weekend is the Measure 114 saga coming out of Oregon. Now, this is a massive deal because it's been ruled constitutional by a federal judge. Wait until I show you some of the excerpts from this decision. It's going to blow your mind. And this thing is going to be expedited so fast to the next level, it's going to make their head spin because it's this level of dumb. Now, everything, of course, is linked in the description box below, and I can't wait to hear what you guys think about this one and spread this out because what you're watching, these actions, these are the steps to the SCOTUS. This is unbelievable. You're not going to believe what I'm about to show you. And of course, make sure you like, subscribe, and hit that notification bell. We are distributing freedom twice daily, and we'd love to have you along for the ride. So, my brothers and sisters, if you're not familiar, Measure 114 was something passed in Oregon that was extreme gun control. We're talking about fees to own a gun, education and licensing to own a gun, training tests to own a gun, can't have magazines, all these different pieces. But this judge, so far this thing's been on hold. So this judge just did the best case of mental gymnastics I've ever seen. And I do this for a living. Check this out. So this is in the United States District Court for the District of Oregon, Oregon Firearms Federation v. Tina Kotek, okay? Now, it's mind-boggling. So I was a bit at a loss how I was going to start this for you. I'm just going to read the conclusion, and I'm going to show you a few of the greatest hits from this decision, which, again, is linked in the description if you want a mind-boggling read. So here we go. Let's get the conclusion really quickly. The Supreme Court has held the Second Amendment protects an individual right to self-defense inside and outside the home. LCMs, or large capacity magazines, are not commonly used for self-defense and are therefore not protected by the Second Amendment. That's more than 10 rounds, by the way. So a Glock that has more than 10 rounds, that's not self-defense. Wait until you hear why. Even if LCMs are protected by the Second Amendment, Ballot Measure 114 restrictions are consistent with this nation's history and tradition of regulating uniquely dangerous features of weapons and firearms to protect public safety. This court accordingly enters judgment in favor of defendants and intervenor defendant on plaintiff's Second Amendment challenge to BM 114's LCM restrictions. The Second Amendment also allows governments to ensure that only law-abiding, responsible citizens keep and bear arms. BM 114's permit to purchase regime on its face sets forth objective criteria for the issuance of permits and does not allow unfettered discretion by permitting agents in assessing an applicant's mental health status to ensure that only law-abiding and responsible citizens can purchase firearms in the state of Oregon. Let's go to the next one. This court accordingly enters judgment in favor of defendants and intervenor defendants on plaintiff's Second Amendment challenges to BM 114's permit to purchase regime. The Fifth Amendment protects an individual from having their property taken by the government for public use without just compensation. But the Fifth Amendment does not prevent the government from exercising its police power to protect the public welfare. BM 114's LCM restrictions are a valid exercise of police power. This court accordingly enters judgment in favor of defendants and intervenor defendant on plaintiff's Fifth Amendment challenge to BM 114's LCM restrictions. So, no. The Constitution says the government can't take your property without sorry, I'm getting flustered. Just compensation, but the police can. What? Okay, let's continue. The Due Process Clause of the 14th Amendment prevents the government from depriving a person of liberty without due process of law. Red flag laws. Plaintiffs have failed to show that BM 114's permitting provisions deprive them of liberty because BM 114's permitting provisions do not violate their Second Amendment rights. You have to have a permit to own a gun. It is given to you by the government. But don't worry, they're going to throw shall issue here in a second. Again, the mental gymnastics are mind-boggling. Because BM 114's permitting provisions do not violate their Second Amendment rights, this court accordingly enters judgment in favor of defendants and intervenor defendant on plaintiff's 14th Amendment challenge to BM 114's permitting provisions. The Due Process Clause of the 14th Amendment also prevents the government from passing retroactive laws, unless the government can point to a legitimate legislative purpose furthered by rational means. BM 114 does not impose retroactive penalties on the possession of LCMs and therefore not retroactive. Moreover, defendants' interest in public safety provides a legitimate legislative purpose furthered by rational means. This court accordingly enters judgment in favor of defendants and intervenor defendant on plaintiff's 14th Amendment's challenge to BM114's LCM restriction. Finally, and then we're going to get to the good stuff. Finally, the Due Process Clause of the 14th Amendment prevents governments from passing laws that are so vague that they fail to give a person an ordinary intelligence fair notice of what is prohibited. BM 114's LCM restrictions give a person of ordinary intelligence fair notice of what is prohibited. This court accordingly enters judgment in favor of defendants and intervenor defendants on plaintiff's 14th Amendment's challenge to BM 114's LCM restrictions. This court enters judgment in favor of defendants and intervenor defendant on all claims. It is so ordered on the 14th of July, that was yesterday, by Judge Immergut. Okay, Judge Immergut just did the most amazing mental gymnastics I could ever see on this planet. The Second Amendment doesn't protect LCMs. Oh, large capacity magazines aren't protected? Well, that's of course. And again, wait till I show you. And permitting requirements to own firearms, that's perfectly fine too. But it's not the takings clause because the government isn't taking it from you. It's the police powers that are taking it from you. Literally, this is going to be sent to the next level so fast. It's so riddled with errors and so dumb that you could not make something up that was this much of a reach. Let me know what you guys think in the comments below, and I will see you on the next one. I'm Braden. See you later.